the military justice system and the civilian justice system are essentially built on the same lines.
Yes.
And the military justice system tries to copy what the civilian justice system does as much as possible. Well, I used to be in the Navy a very long time ago,
Yes,
and operated in this system. And when you're involved in the system, it doesn't seem unfair. There's a new Act of Parliament just came into force, which means we now have to have, the way it's phrased, at least one male and one female board member, jury if you like, on each case. I hope service personnel in the main feel that when they have transgressed and do come before the court-martial, they are tried by firstly a court that's fair and secondly a court that understands.
Hello everyone, welcome back to Fauji Days. This is a very unique episode as for the first time we are interviewing a distinguished foreigner who has served in the Royal Navy in the past and is now a senior judge in the Judiciary of the United Kingdom. His Honour, Judge Alan Large, joined the Royal Navy in 1979 and was in service during the First Gulf War. He left the Royal Navy as a Lieutenant Commander in 1993 and pursued a career as a civilian barrister on the Western Circuit. He served as resident judge in Germany from 2010 to 2013 and then as resident judge in Bulford from 2013 to 2020. He was appointed the Judge Advocate General, also known as JAG, in 2020 by Her Majesty the Queen. The JAG in the UK is a civilian judge appointed as part of the independent judiciary through the Judicial Appointments Commission by the Sovereign on recommendation of the Lord Chancellor. The term JAG is a historic and legacy notional nomenclature which is still being retained, though he or she is a proper judge and not a part of the armed forces or JAG as we perceive in India. Although Judge Large has served in the armed forces, there is no such requirement for the JAG in the UK to be a former military officer. The JAG of the UK also presides over civilian courts. He is the judicial head of the service judiciary comprising service courts which are equivalent to Crown Courts. Judge Large was here in India to attend the Commonwealth Law Conference in Goa, which is held once every 2 years in a Commonwealth nation and is attended by judges of the Supreme Court and other courts, ministers, jurists from the Commonwealth nations and more. While in India, he agreed for an interaction for Fauji Days. He is being interviewed by NCC cadet Sohrab Singh of Saint Kabir Public School, Sector 26, Chandigarh for Fauji Days in a freewheeling interaction. Sohrab himself is a keen observer of military matters, geopolitics and international relations and hails from a military family.
Hello everyone, welcome back to an episode of Fauji Days. Today we are here with a very interesting guest. His name is Judge Alan Large and he's the Judge Advocate General of the United Kingdom. Welcome, sir.
Thank you very much.
I'm glad to have you here because we've never really had a foreign guest before, and I'd like to ask you some questions about the British justice system and also regarding the British military.
Of course.
And if you don't mind, shall we start?
Yes, of course.
So tell us a bit about the British military justice system and the justice system in general. What are the differences between our system and yours?
Both systems are founded on the same principles. They are based on the British system that, if you like, was left to India when it gained independence. And since then, they've gone perhaps in two different paths. The military justice system back in the UK has been subject to a considerable amount of scrutiny in the European Court of Human Rights. A lot of people think, just out of interest, that because the UK has left the European Union, we're not subject to the European Court of Human Rights. We still are.
Oh.
But before Brexit, the European Court took an interest in our military justice system. A number of cases were taken to the court by lawyers, quite rightly, in the UK, suggesting that the rights of soldiers and sailors and aviators were being compromised, their human rights to a fair trial. And there was significant concern about the independence of the various parties in the military justice system. The military justice system and the civilian justice system are essentially built on the same lines.
Yes, sir.
And the military justice system tries to copy what the civilian justice system does as much as possible. But before the European Court gave its judgments, including an important case called Findlay, we found ourselves in the services, in the armed forces, with a confusion of authorities. There wasn't a clear separation of independence required from the various players in the organization. So we had a convening authority, and the convening authority would convene the court, appoint the prosecutor who would draft the charges, appoint the judge. The convening authority would appoint the board members, the jury, if you like, and the convening authority, after the trial had taken place, would then decide whether to review that decision, guilty or innocent, or the sentence, and could overturn it. And the convening authority could also stop the case in its tracks if they wanted to. It didn't happen very often. But you will understand, and I'm sure everyone understands, that doesn't look very fair to have all that authority vested in one person when the justice system is supposed to be independent. So, cutting a long story short, a long series of acts of parliament culminating in the Armed Forces Act 2006 changed the whole structure of our system. And we now have an independent court authority, independent prosecuting authority, independent judges. All the judges, like me, are civilian. We work under the Ministry of Justice. So the Ministry of Defence, which runs the services, obviously, cannot have any influence over us at all, and neither do they try to. We have, as I said, independent prosecutors, independent defence advocates. So we've managed to replicate the independence of the civilian system in our military justice system. India hasn't yet taken that course. I don't know whether she's going to. I had a very interesting meeting yesterday in Delhi with the Armed Forces Tribunal and the Armed Forces Bar. They made me very welcome indeed, and some really good discussions about what we've done in our system. Just because we've done it doesn't mean it's right at all. But it'll be interesting to see what India decides to do. I know there's a lot of talk about it. People have written quite passionately about it in India. But at the moment, you have some of those systems that existed before the European Court got involved. I know your Supreme Court has significant powers in changing legislation or striking down legislation. All I can say is our system seems to work, because since 2009, when the main Reforming Act came into force, no one has taken us back to Europe. So we must be doing something right. So we both share the same roots. We've gone one path. India's on another path. The future is who knows what will happen in the future.
Interesting. So I've heard that the Supreme Court in the UK does not have like as much power as ours does. So
the Supreme Court in the UK is essentially what it is. It's the Supreme Court. It's an appellate court, and it exercises an appellate function only. And so you wouldn't find the Supreme Court essentially striking down laws, which I gather your court can.
Yes, sir.
That's a difference, I think.
So you mentioned the Findlay decision taken by the European Court of Human Rights. So can you expand a bit more on it? Can you elaborate a bit? Tell us.
It was on this point of Mr. Findlay had committed some quite serious offences. And you have to exhaust all remedies all domestic remedies before you can go to the European Court. What I mean by that is you have to go through all the courts. So he went to the Court of Appeal, Court Martial Appeal Court, he went to the Supreme Court, and then he took the case to Europe. And their concerns were, as I say, that there was no independence. The officers who tried the case and found him guilty were junior to, and in some ways in the chain of command of, the convening officer who convened the court martial. When I used to be in the Navy a very long time ago, and operated in this system. And when you're involved in the system, it doesn't seem unfair. When you look back on it, when I look back on it now, I can see how it did seem unfair, and I can see why the European Court did what it did. And I think they were right to come to the decisions they did. But it was the lack of independence in the constituent parts of the system that European Court decided that Findlay was right to say that his rights were compromised.
That's very interesting that the European Court of Human Rights. I mean, it's good that this decision was taken because the independence of the judiciary is really important in a democracy, and this independence should be valued in order to maintain a democracy. And without waffling further, I'll move on. I have sort of veering away from law, but the position of JAG in the UK, Judge Advocate General, it has military connotations, but why has the UK retained this title despite it being a civilian position now?
It's a historic title. It dates back to 1666, in fact, and I am the 55th Judge Advocate General. Some people have held the office more than once. But so there's a historic title, and the Judge Advocate General, the judge in bygone days, the Judge Advocate General would prosecute cases on behalf of the Crown and administer the court as well. So they had an all-embracing function. A long time ago now, the title has been kept. So I'm not an advocate. I'm not a general, but the general comes in the same way as Attorney General or Solicitor General. So it describes the breadth of the job. It's a historic title. People know what it means. Before I was the Judge Advocate General, I was an Assistant Judge Advocate General. That's a bit of a mouthful, and not everyone understood what that meant. I had to explain that quite a lot. But they are the judges who are on the ground, sitting in court all day, dealing with cases in the court-martial and the other service courts. My job now as JAG, I still do cases. I also sit in the civilian courts as a judge, a circuit judge. But I'm responsible for the leadership of the service judiciary. And also I work quite closely with the MOD, the Ministry of Defence, in developing strategy, policy, trying to point out areas where we might make improvements, and assisting, guiding the Ministry of Defence along to bring those improvements into play.
Great. So more of a historical title, easy to keep track of. And
well, history and the law go hand in hand, really. The law survives on precedent, so we can still quote cases back hundreds of years ago, which apply today. Our main act of Parliament in relation to violence is the Offences Against the Person Act 1861. It talks about grievous bodily harm, and no one would use that expression now, but the law is still in force because it works, it's clear, it's well understood, and there's however many years of authority on how it works since 1861. So history is all around us.
To some extent, some provisions of the Government of India Act 1935 are still valid. I mean, not valid, but even the Constitution, a lot of provisions from that act are still active in a sense.
I wear a wig in court, a horsehair wig. Why? I know your courts, your judges don't wear them anymore. We still do in crime. Why? Well, it's a tradition. Is it one we're going to do away with? Probably no time soon.
I hope not.
Because if you do away with tradition, you never get them back. Sometimes people want their lawyers to look like lawyers. I was talking to a colleague of yours today about this earlier on. People who come to court, particularly if you're a young advocate, it helps if you look like a lawyer. And I can remember when I was a junior barrister going down to deal with a drug addict client in the cells in the Crown Court, who perhaps was not in the best frame of mind in a variety of ways. But if you walk in looking like a lawyer with a wig and gown and everything else, it helps you sort of take charge of the situation. Of course, people without those robes can do it as well. It's not unlike the services, though. You look like a very smart Army cadet. That will help you take charge of a situation because people look at you and think, he knows what he's talking about.
But I don't.
Of course you do.
Now, again, I digress a bit, but do you miss your time in the Navy? How was it?
Well, I left the Navy in 1993, which is a very long time ago now. But the answer is yes, you do miss it. there's a saying, you can take the man out the Navy, but you can't take the Navy out the man. And so I still regard myself as a naval officer. I was a lieutenant commander, and I'm still very proud of that. I had some amazing experiences. I was a barrister in the Navy, but the Royal Navy has a wonderful system of allowing you also to do a logistics job. And so I had a number of sea time jobs at sea, frigates, survey ships. I traveled a lot in the Navy. I saw some amazing sights. I met some fantastic people. And I was able to practice and learn and practice law in the Navy as well. And it's quite strange when I now work with a naval case in the court-martial 40 years later. You find yourself with going straight back into the language and reminiscing about things.
Yes.
Traditions are traditions. They continue. And so I very much enjoy working with the services. I went back into the job after my time as a civilian lawyer. But yes, if I had the time to do it again, I would certainly do it again.
Even, I mean, the UK, it's a seafaring country traditionally. And I love your song, Heart of Oak.
Yes.
That's one of my favorite
It's a
marches.
good one. You've got the wrong uniform on.
Oh, well. No, I still prefer the army, I think.
Well, there we are.
We're better.
That can't be helped.
We're better. So what are some progressive laws that have been introduced in the UK regarding military justice?
I only deal, I know your Armed Forces Tribunal deals with appellate cases from the court-martial, as well as administrative matters, pension, disability, promotions, appointments and the like. I only deal with the criminal side of things. But there is a constant focus on trying to improve the way we do things. Life can be quite difficult in the services for people who are victims of offences, particularly if they're young soldiers, and particularly if the behaviour that they're being subjected to is some form of harassment or sexual offending. And so we're very keen to try and make sure that everything is done to facilitate their ability to complain, to say this has happened to me, to stand up, to be looked after during what is always a difficult process of going to court, during the court process itself and afterwards, because the trauma caused by that type of offending doesn't stop as soon as the verdict comes in. So there's been a lot of work by the Ministry of Defence, the services themselves, and in the courts to try and improve that. Where, for example, there's a new tri-service victim unit, which has just opened up in the south of England. It will provide a joined up support service for victims in all three services. And I'm hoping that will make significant improvements. Small things on the appearance of the way we do business in the court. There's a new Act of Parliament just came into force, which means we now have to have, the way it's phrased, at least one male and one female board member, jury if you like, on each case. What that means is you couldn't have an all-male board or an all-female board. In reality, it was aimed at stopping all-male boards in cases. So we have to have one woman, one female officer or warrant officer on a court-martial board now. Funnily enough, just last week, I was in the Military Court Centre in Wiltshire, and I went in to meet the board members, and they were all women. And I had to say, I'm very sorry, but we're going to have to find a male member. And there was a waiting member who was male. So it was the first time I've had that, because there are a lot less females in the army than males. But that's a progressive thing. It makes the court look more diverse, because if you have 5 men all wearing the same uniform, it doesn't have an appearance of diversity. And we're working on trying to perhaps bring a little bit more diversity to the board members as well. Anything we can do to get cases through more quickly. Delay is a problem, but at the moment we're able to list a case for trial in a case involving a sexual offence within 6 months of it being sent out by the prosecution. That's not bad going. It sounds like a long time, and to everyone involved, defendant, victim, witnesses, it's an age, but it's quite a lot to do to get a case to court. And I'm quite happy that is a reasonable time for the case to be listed. Sometimes it takes a long time to get it to court in any justice system. I'm sure it's the same in India. Everyone
Even
has,
longer.
well, everyone has a phone, 2 phones. People of your age have got all sorts of other bits of equipment that can retain data. And if you need to look at someone's IT equipment, that's going to take forever because there's so much to look at. There's a huge backlog. That sort of thing takes time. And I'm quite keen to try and reduce it as much as possible.
Yes, sir.
And introduce ways but that's really for the police and the prosecutors, not for me. But I do encourage them, as they know, to try and bring cases through as quickly as they can, because there is no doubt, and it's an old-fashioned expression, that justice delayed is justice denied. Because not least because people can't remember what happened. Trying to remember what happened to you in a traumatic situation 2.5 years ago, it is quite difficult. People muddle it up, they get it the wrong way around, they remember it, the memory processes things in different ways. And then when they're expected to give a clear, consistent account, juries, boards in any court are concerned about the fact that it's coming out different from what they said the first time. And they start thinking, well, I wonder if I can rely on this. So it's really important to try and get cases through as quickly as possible. So that's the sort of thing we're trying to do to keep the progress going that was started in the 2006 Act, and then move it forward.
And I mean, especially for the military, traumatic incidents can be even more pressurizing, because the stress and strain of military service piled up along with all these legal issues, and they can really have a negative effect on.
Well, this is why you need a military justice system.
Yeah.
That's why we've got one. It's why you have one. Some countries don't. Some countries have said, no, we are going to try all our military cases pretty well in civilian courts. And for them, that works. It doesn't work for us. We prefer having the ability to, hopefully in good time, provide a disciplined service for your service personnel, officers and enlisted people. The importance for that is that you need to be able to maintain discipline. Soldiers, service people need to do what they're told without thinking about it, particularly in a combat situation. Everyone knows that. Everyone knows when they sign up that they are signing up to potentially life-endangering experiences. And so discipline is crucial in the services. And to reinforce discipline, you need a proper justice system. So you have the commanding officers have got their own justice system, their own discipline system. Summary level, I don't deal with that. They deal with that. We deal with the more serious cases in the court-martial. But it has to be effective and it has to work. And the reason that we have a military board rather than just me as a civilian judge or a civilian jury is that those officers, warrant officers, and now staff sergeants or equivalents, bring together that experience. They bring together what you're talking about. They understand the pressures that are on people, particularly when it comes to sentencing. If you're sentencing someone who's committed an offence on operations, or very soon after coming back home from operations, there are often things at play which can affect their behaviour. A number of service people, sadly, suffer from post-traumatic stress disorder from things they've seen or experiences. And as an expert court, we can take that into account with appropriate medical evidence to support it. You don't just accept it. But I hope service personnel in the main feel that when they have transgressed and do come before the court-martial, they are tried by, firstly, a court that's fair, and secondly, a court that understands. We still have sentencing guidelines. We still have to have regard to what happens in the civilian courts. People commit serious offences, they will still go to prison. Less serious offences, they might go to military detention. It's not a get out of jail system at all, but it's a bespoke system designed to support the chain of command, to support operational effectiveness, but also to support the service people individually who are there in the service and find themselves accused of criminal behaviour.
I mean, what are some commonalities that you've noticed between the Commonwealth countries? And we already talked about India and the US or other democracies.
Well, but the foundation for most Commonwealth countries is the same. Interestingly, one of the reasons I'm here in India is to go to the Commonwealth Lawyers Association conference next week in Goa. And I'm speaking with an eminent panel of experts in military justice about the Commonwealth Military Justice Project, which has been launched by the Commonwealth Secretariat and approved by the law ministers at their last Commonwealth meeting. And basically, it doesn't really apply to India. India is a big country with the ability to administer itself, obviously. But there are some smaller countries in the Commonwealth who have less resources, less infrastructure, perhaps, and might need a bit of guidance and assistance in moving their military justice system forward in the way I said right at the start of this interview. And so what we're hoping to do is provide what we call a principled approach. We're hoping to develop some principles of military justice. There's been some seriously impressive work on this in the past. We're going to build on that. It would be very nice if we could end up with some Commonwealth approved principles of what constitutes a military justice system, the bare bones, the basic elements of maybe 10 bullet points. To be an effective and fair military justice system, you should have an independent prosecutor, an independent judiciary, an independent tribunal, a good prison service, detention service, all this sort of basic fundamentals that perhaps aren't always available. We're hoping to recruit an expert to draft some model laws. We've been working quite closely with some countries in the Caribbean who are keen to develop their military justice systems, one in particular. And so it'll be a good way of bringing the Commonwealth together and trying to produce something that will assist in bringing military justice onwards. And I very much hope that colleagues in India will help.
Well, hopefully we can all develop our systems together and learn from each other, because it's very important to give our military personnel the means to acquire justice for themselves as well.
They must have the support. They must have access to justice, at least as much access to justice as their civilian counterparts. Quite a lot of me thinks that they should have better access to justice, but it must be at least as good. And if it isn't, then countries are quite keen to improve that. And the Commonwealth speaks for itself. There's a commonwealth of knowledge. And I'm not saying for a moment, please don't think I'm saying for a moment, that UK has got it right. All I can say is that we're going out to the Commonwealth to get as much information as we can. So we've got a military justice expert from India. We've got Australia, New Zealand, Canada helping. The Americans are helping as well. No longer part of the Commonwealth. But it's a global, it's not a global effort, but it's a big effort to try and bring military justice into the 21st century.
Since we've come a long way, our militaries have evolved, our systems have evolved, our laws have evolved.
Well, if you start looking at what lies ahead with IT and technical weapons and robots and all this sort of thing, we're going to have to keep up. We can't just sit back and expect it all to happen if we don't look ahead. I'm not an international lawyer. I'm not a human rights lawyer. But some of these changes that are happening, we're going to have to keep up with.
So, sir, I'll ask you a few questions and you have to give me a reply in one word or one sentence. Very brief questions.
Here we go.
What was your favorite posting in the Navy?
Plymouth in the southwest of England.
What has your favorite appointment been?
In the Navy?
Yeah.
To be the supply officer and logistics officer of Her Majesty ship Brazen in 1991 to 1993.
Wow. Chandigarh or Delhi? No diplomatic answers.
At the moment, Chandigarh.
Great. Navy, Army or Air Force?
Navy.
Fair enough. Frigates or destroyers?
Ooh. Then frigates, now destroyers.
Fair enough. And last question, dosa or pancakes?
Today, dosa. Next week, pancakes.
Thank you for coming here, sir. Thank you for letting me interview you. And it was definitely a really eye-opening experience, not just for me, but for our audience watching in India and all across the world. And I hope you enjoy your time in Chandigarh, and definitely better than Delhi.
So, Rob, thank you so much. Thank you for asking me. I've been made very welcome in Delhi. I've been made extremely welcome in Chandigarh, and I very much enjoyed meeting you and answering your questions. Thank you very much.
Thank you, sir.
Friends, our Faujis have been and continue to be the lifeline of our nation. Come hell or high water, they have always been there for us, whether in times of war or natural calamity or any other challenge India has ever faced. And the culture, traditions, and history of the Indian military are part of a rich heritage, painstakingly preserved by one and all. To cherish and celebrate this heritage, a unique initiative called Fauji Days has been launched by the budding startup 99 Beagles. So what is Fauji Days? Well, it is primarily an oral history project based on interviews and recordings. Faujis always have tons of stories to relate, many of them inspiring, thought-provoking, funny or engaging, and highly satisfying for the curious, especially young adults in their formative years. These engaging interactions between officers, men and women from our services, with young adults from schools and universities are being captured on camera by us. We want to showcase the diversity of lived experiences on the one hand and the perceptions and expectations on the other. Allow me to also add that the scope of Fauji Days initiative is not limited to just oral history. It also encompasses the written word and the world of military publishing. Already, several books by eminent military authors have been published under this umbrella, and all have been well received by the readers. The Fauji Days website is another crucial resource designed to house the diverse aspects of this project. It features multiple blogs, reference and archival material, and a community newsletter that highlights the progress made as well as the new recordings and books. Feel free to log on and subscribe. I warmly welcome you to be a part of this initiative, no matter what color uniform a Fauji wore, or whether he or she served on terra firma, flew in the air, or rode the waves. The fact remains that each one of these brave hearts is a reservoir of remarkable tales and cherished memories. Fauji Days wants to share these memories and tell these tales to a much wider audience. If a nation is made of memories, then Fauji Days will prove that Fauji men and women have contributed some of the best. As a Fauji, you can reach out to us and tell us about your rich experiences. Get in touch and we will revert with an audiovisual team equipped to capture your recall. Or if you're too distant, we can guide you about how to record and send it to us. Of course, you can also write your tale and send it to us to be featured here. We have the wherewithal to capture you on video from whatever location on the planet. All we want is to know your story so that India knows her story better. It is incomplete without yours. Please also feel free to send your contributions to this archive of India's valor in the form of nostalgic pieces, anecdotes, pictures, or other content you may wish to share with the wider Fauji Day community. On behalf of Team 99 Beagles, I thank you. As they say, Fauji Days never end. In fact, they are just beginning. So, Fauji Days forever. Jai Hind.